phone, is that a text that you sent to Mr. Wright? So you were just reading that verbatim?
It was,
okay.
And I just got his personal text. Apparently, I had been trying to reach him via some service that goes to his voicemail. So my investigator was the one that was always able to contact him.
Okay.
So I'm signing on now.
Okay. And so he had said that he sent something out to everybody last night, but nobody seems to have received it. Just me. Just to you.
He said his words were sent. That's what he said. Sent.
Okay.
But
so I'm going to wait to see if there's any response, but because my understanding was that the court's instructions were that either Ms. Love or one of us was to email and copy everyone on that email so we could all be apprised of the conversations that's going on back and forth. That hasn't happened.
That's correct.
Judge, that Mr. Adams is correct. I do apologize for the informality. I am not 100%, and I was just trying to make sure that I got what the court requested. So I'll delegate to another person on another occasion to do that. But I had my phone in my hand, and I was there, and I wanted to make sure that it got sent. And I'm looking at a Gmail thread that I'm going to try and send to everybody. It looks like this is something that Mr. Wright sent that I can't open in terms of the attachments. I'm just going to forward it.
Okay. And then maybe you could write an email to Mr. Wright and copy everybody and ask the same thing and ask him to respond to everybody.
Yes, I sure will.
Thank you.
Which I think is
what I asked be done yesterday. It is.
Yes. Otherwise, I could have sent the email. As
correct. Yes, I assumed it would be done the way that I instructed.
Let me, while I'm thinking about it, Judge, let me say this also. There was reference made to whether or not Mr. Wright or anyone else responded with anything that would be right for an in-camera inspection. So it just occurs to me that on last week is when Mr. Wright was identified by the state as a potential witness. That's when they indicated they subpoenaed him.
Right.
At the time that he became a witness, any correspondences relevant, germane to his testimony would have needed to have been turned over. That would have been their obligation. And so we shouldn't have had to ask for what we asked for yesterday. They should have turned that over automatically once he became a known witness to them. They hadn't done that. And so, I don't know what.
Okay,
what I can ask for to do at this point.
Was it Friday that he was identified as that you put him under subpoena, or Thursday? I can't remember.
Truthfully, I can't remember. I did tell the court and him, I think, on the same day, but I can't remember which day it was.
And then it was yesterday that you forwarded all of your correspondence to him. And then yesterday evening that we sorted out the idea that maybe his correspondence back to you should also be included. And I don't think there's anything that I needed to review in camera for Mr. Wright. I think you were just going to share everything, right?
Right. I am. That's all. That's what I'm doing. Okay. Please.
With regard to the attorneys for the other defendants who have pled, co-defendants who have pled, as far as I know, those attorneys are not under subpoena or planning to be called by the state at this point, correct?
No.
Okay.
No.
So we're sort of in a different situation with regard to them.
Yet I still believe, Your Honor, that we are entitled to get those emails if there's any exculpatory material.
Ms. Love can either share them fully or I can do an in-camera inspection.
And, Your Honor, for reasons that may or may not be apparent, I would prefer the in-camera inspection in terms of, I don't think that there is any circumstance that anybody said.
Okay, we'll just get them gathered together and get them forwarded to the court, please.
Thank you. Yes, Your Honor.
And I'll make them a part of the record regardless.
Yes, Your Honor. Yes, Your Honor.
And once you send that email, I need everybody to approach for a matter that I want to discuss as a bench matter.
And so I'm looking at, he did send something. I didn't see it on my phone this morning. I see it came at 10:24, so I forwarded just that whole thing. I haven't opened it. I don't know what's in it. And then he said, he also sent, here is an ancient one from 2015, not related to this, just showing I'm checking my entire email, and one I sent over the weekend. Okay, I will forward this as well.
Okay. All right, so I guess when you all get that, you can take a look and see whether you still want Miss Love to do everything by email as well, or whether whatever Mr. Wright sent back will suffice. And then next time, I really would like for you to follow the instructions that I give you, please. Okay. Good. Thanks.
I just sent to everybody everything that he sent to me.
All right.
And requested that and I think the first one I failed to include Mr. Wright on, so I included the email that I just sent to everybody in that last one.
Okay.
And when the court instructs, I will approach.
All right. Well, I'll give everybody a few minutes to take a look at what just got forwarded.
In Your Honor,
Yes,
is there
sir.
any way the court can order a date certain by which we will get these emails or any communication that occurred between the state and the prior attorneys for those defendants that took pleas, given that most of those pleas were, not all of them, of course, but most of them were a year and a half ago? I'm not saying the end of this week, but if we could just get a date, Your Honor.
Well, I don't know that you're going to get any of them. I mean, I'm going to take a look, and if there's anything.
I don't have confidence that we're going to get any of them either. but if any exist that we should be provided with, if we could just have some type of a deadline, Your Honor.
How long do you need to go through and find correspondence with the other attorneys?
Since we're going to be in court tomorrow, I think I can go.
What? We're going to be in court tomorrow. We're just not going to have the jury tomorrow.
That's what I said.
Okay.
Since we're going to be in court tomorrow, I apologize. I'm still not quite loud as I should be, but I'll give them to the court if the court will allow me till tomorrow at noon so that I can give them all to the court.
That'll be fine.
Thanks.
Emails, Ms. Love, that you just forwarded, are the attachments the same on both, or is this two different sets of attachments?
Two different sets of attachments. He sent me
Okay.
one that pertained only to the negotiations, and then he sent a second email that he said
Was other things not related to this?
one was related to the 2015 case, and then one was related to, I haven't read it in its entirety, but it's some attachments I can't open. He said he sent them
Okay.
this weekend or something.
This weekend?
I might have that wrong. I just sent what he sent me. It's just what he sent.
Okay.
Your Honor, there, Mr. Wright appears to have sent some, well, I don't really know, but based on what's been forwarded, Mr. Wright appears to have sent perhaps a PDF that's more an image of the email, and which does not actually contain the attachments themselves. However, since at least the one I'm looking at, which is from Saturday, September 7th, 2024 at 9:52 a.m., that reads from Derek Wright to Adrian Love, looks like we had original, then 3 updates. Also, my notes. Honestly, not sure my testimony will be helpful. There's 5 attachments there. We obviously, since it's just an image, we can't see those attachments.
Okay.
But since the email was sent to Ms. Love, I'm not sure if she'd already provided that one from Saturday morning at 9:52 a.m. But if not, could we have the actual email sent to us?
We'll have Mr. Wright here in court with us very shortly, so we can just bring him in before we call the jury in and let him know that we need it in a different form so that we can read.
But I believe Ms. Love will have that, since it was an email from Derek Wright to Ms. Love Saturday morning.
Okay, so this would have been over the weekend with regard to his testimony, I guess. So can you
I'll check.
find those and forward them?
I just forwarded the one that he sent Saturday at some point at 9:52 a.m. And let's see.
Thank you.
first. I may be overthinking it, but information regarding between Mr.
You're going to need to speak into the mic.
Does the court wish that I sent all communication, including that includes getting his client here, everything, or just the stuff that relates to this?
Why don't you just send everything?
Yes.
I mean, it looks like y'all already had all of that in the first set of attachments. All right, does that email that you just sent, that's now everything? And those are basically just two conflict letters that Mr. Wright had forwarded. Will that be everything?
I think so. I'm checking.
Okay.
I'm just checking. I think. And that was. No, 27/2022 at 8:43 p.m. Right. I'm just looking at all of them. December 22, 22nd. That's 12/27/22, 8:43 p.m.
8. Okay. Oh, okay. The ones that are the paper copy? Yes. Okay. Sorry. All right, then that ought to be everything. Can y'all approach for a moment?
I'd made an objection on yesterday and asked that be kept out, and I don't recall what the court's ruling was. Can I have some clarity on that, please?
Sure. The court's ruling was that if Miss Love ends up tendering that for admission, that can be redacted out. It can just say quote and then blacked out quote. So it's clear that there was some quotation that was going to be included that got altered. And asked if there were any other portions that y'all would like similarly redacted, and that was the only one I heard. But
all right, thank you.
You know, if you notice when they're being tendered, just let me know that, and we can handle that as well.
Will do. Thank you.
All right.
Your Honor, as it relates to the correspondence to and from Mr. Wright and the state. I just want to make sure that there's not any, the state intends to, for the purposes of proving their existence, to tender them, and of course with the redactions that we told the defense and the court that we would make. But as I'm thinking over it as an evidentiary matter, the existence of the request itself is evidence that we think should be permitted at trial.
Okay, and so what is it that you're saying?
For instance, I would be tendering a conversation with Mr. Sledge. Given the cross-examination, did the state ever try to sit down and talk with you? Did they ever request to talk with you about Jeffery Williams? All of those kind of questions prior to making the December 28, 2022 plea. So the existence of the request itself is evidence that we would be tendering, not just making the inquiry of Mr. Wright.
Okay.
Well, they'll have a witness on the stand.
Yes.
That they can ask whether or not that request was made, and that witness can testify yes or no. If, depending on what that witness's response is, there may or may not be a need to impeach that witness. And so I can't think of any legal reason that the document itself would be necessary unless for some legal exception, for example, impeachment.
The existence of the request itself, it's not an attempt to impeach Mr. Wright. It's me tendering a request that was sent to Mr. Wright through Mr. Wright.
Well, the document...
Don't interrupt, please.
Excuse me.
Remember we had decided that we weren't going to be interrupting each other?
Understood. I thought she was done.
In terms of hearsay, if that's what the objection is, there's nothing hearsay about it. The document itself, it does not constitute hearsay. We're not offering it for the truth of the matter that it's actually just a request. And the document, the existence of the document is evidence in itself.
May I respond? My position is that it is a statement from the DA's office, from the author of that correspondence. It is an out-of-court statement. It would be hearsay, but more importantly, it would not be necessary. The evidence that they're seeking to introduce is the fact that there was a request made or not for a meeting with the defendant. And if the witness can testify to that fact and it testifies affirmatively, then there is no need for the introduction of the actual document itself.
Okay, but there's no evidentiary rule that says that if you can get the information in through the witness, you can also offer a document that shows the same thing.
But then what would be the purpose of them offering the document if they have the testimony?
Further proof. All right, let's get the witness in.
Over here. Jasmine. Over here. JB. Okay, this looks good. Okay. This is her. Okay, so we'll call. What is it? Oh. Your Honor, Lieutenant Wright, Lancico is showing me correspondence from Mr. Wright that was received today at 7:53 a.m. Good morning. Is he still a few blocks away? Good morning. Traffic has been terrible. I am a few blocks away from the courthouse, but depending on how long it takes to navigate these blocks, park, and get into the courthouse, I might be just a little late. I'll ask her to call him because we reached out at 7:53. So I'm going to ask her to call him.
Okay, so is he not outside right now?
I'll get her to call him
Okay.
right now.
Hope it doesn't take an hour to navigate a few blocks around the courthouse. All right, so we'll be in recess until we have the witness.
My apologies.
You're welcome. He's here. He's here, Mr. Weinstein. We're ready for the jury.
Good morning. Your Honor.
Morning. Thank you. All right, everybody can be seated. And before we pick back up with Mr. Wright, let me just, while I'm thinking about it, I know there had been a couple of inquiries, I think maybe from the jury and from attorneys about what our plans were going to be for Election Day, November 5th. And my plan is to have court that day, and I'm going to have my assistant forward the list of early voting locations and times. It appears that Fulton County has early voting starting October 15th and running all the way through November 1st, and that includes Monday through Friday, Saturday and Sunday hours, and almost 45 different locations during early voting. You can vote at any of the early voting locations. It doesn't have to be your precinct. So anybody who wants to vote certainly is going to have plenty of opportunity to early vote. We will probably adjourn court a little bit early, maybe a few hours early on November 5th, but we're not going to take that entire day off. All right. Okay, Ms. Lev, go ahead and continue with your examination.
Thank you, Your Honor. And good morning again, Mr. Wright. How are you?
Good morning.
Judge, with the court's permission, I'm going to just use this microphone.
Yeah, that's fine.
Mr. Wright. Never mind. Mr. Wright, yesterday we were discussing representation of clients that you've had and your responsibilities as it relates to them. Would you tell the jury what it means to make an entry of appearance when you begin to represent a client in Fulton County Superior Court?
When we are hired to represent a client, and this is really civil, criminal, anything, you make an entry of appearance with the court so that you are officially letting the court know, I have been retained to represent this individual in whatever the matter is. That entry will generally...
I'm sorry, Mr. Wright.
That's all right.
I'm trying to get you to speak about
That, I'll just sit back. That entry of appearance will identify the court, identify yourself, identify the client, and basically shows your role that you are officially in that case.
Is it required that you make an entry of appearance anytime that you begin to represent a person in a criminal matter in Fulton County Superior Court?
Yes.
Okay. And once you make an entry of appearance, does that announce to the court, the state, and any other attorneys that are interested that you solely, along with whomever you designate, are the person that is representing that person?
Essentially, yes.
All right. And once you make an entry of appearance, are you bound to that person until you yourself just... Better question.
Yeah.
Once you make an entry of appearance...
Let me answer it in two ways. In terms of the court seeing you as the official representative or the authorized representative of that person, until you're released by the court, you remain that person's attorney as far as the court's concerned. Sometimes there may be a falling out or just a parting of ways between attorneys and clients prior to that. But until you get the court's approval on a motion to withdraw or a substitution of counsel, but until you're released by the court, you remain that person's attorney.
Would you tell the jury the steps that a criminal case, for instance, when you send in an entry of appearance or file an entry of appearance, is it always at the same place in a criminal proceeding? At the very beginning, middle, end?
It really depends on when you're retained by the client or the client's family. Sometimes you can come in the very beginning, before a case is indicted. That's when you hear words like prelim or first appearance or things of that nature. Or much later on, at indictment, where you have arraignments and other initial proceedings for indicted cases. Or sometimes you're hired much later in the process. The case may be on the trial calendar already. So it really varies with each case. When do you actually come on board?
Do you recall the stage of trial or the stage of the criminal process for case 22 SC 183572, this particular case you're testifying in, or the predecessor indictment that this superseded? Do you recall the point at which you filed an entry of appearance for Antonio Sledge, the point in this case, not necessarily the date, just where the case had gotten to?
I don't remember the exact date that I filed an entry of appearance, but I was involved in the case before it was indicted, meaning he was affected by this case long before indictment. So we had some initial things, a preliminary hearing, and things of that nature that we had to deal with. So I can't give you a date, but very early on, even well before the case was indicted, I was involved in the case.
Okay. And when you say you were involved in the case, are you specifically referring to what ultimately turned out to be this indictment?
Yes.
All right. When you have filed an entry of appearance and you remain on the case, and the case is placed on a trial calendar here in Fulton County Superior Court, and it reaches, say, a final plea stage, would you explain to the jury generally, not fully in detail, but what final plea means as you understand it here in Fulton County?
Okay. To give you a quick primer on criminal cases, once the case is formally charged or indicted, you have an arraignment. That's where you formally plead guilty or not guilty. Then you have what we call sort of a discovery. That's where the state provides what their evidence is. The defense, we file motions to suppress, motions for more discovery, motions for experts. I mean, a variety of stuff, but we're sort of developing the case to make sure we're getting everything out and sort of on the table. Then after that process has sufficiently occurred where discovery is exchanged, certain motions may be filed, may be heard, eventually the court puts it on a final plea, which says, hey, all this stuff has been done. Have you come to a decision on what you're going to do? Do you want to proceed with trial, or do you want to resolve the case? And a final plea date is significant because there's generally two kinds of pleas. There's non-negotiated and negotiated.
Before we get into that part, are you able to encapsulate, without going further down the line into non-negotiated and negotiated and all of that, are you able to just encapsulate what that date is?
In terms of what a final plea date?
Yes.
Well, final plea is your Fisher cut bait date.
All right.
Okay.
And on that Fisher cut bait date, are your only options to enter a plea, go to trial, or do you also have the opportunity or ability to request something different than either going to trial or entering a plea?
I would add a third. Take a plea, go to trial, or beg for a continuance. So sometimes you can get it, kick the can down a little bit and say, hey, we need more time. So one of those three, and it still brings you back to final plea date as either
at a later time, though.
Yeah, at possibly a later time. It's, are you going to take a plea or do you want to go to trial? All right.
And are there any particular reasons that might guarantee you a continuance? Any particular of any sort?
If there's a major issue, condition of the attorney, the client, something extraordinary generally. Some courts are a little stricter on holding that final plea date and holding our feet to the fire, and other courts are a little more flexible.
Were you to tell a court that you simply are not ready, you cannot be effective, are you generally given a continuance if you request one?
Generally, yes, and I would caveat depending on the judge, depending on the court. Some courts, again, are much more firm and strict because, again, they're trying to keep cases on track.
Right. Will you know what the court is going to do without asking?
Generally, if you've been around long enough, you've gotten to know the tendencies or the requirements of the different courts, yes.
Let me ask a better question. Can you state with certain whether you're going to get a continuance if you don't ask for a continuance?
Your Honor, I'm going to object for relevance.
Sustained.
All right. So, are you able to tell the jury if you were Mr. Sledge's attorney even before this case was indicted?
Mm-hmm.
Did you appear with Mr. Sledge at a plea and arraignment? Was there a plea and arraignment for him that you were a part of or someone on your behalf?
I'm not sure. Okay. And to explain that, this case occurs. I have a heart attack in March of, 22. So from that March 22 and then heart surgery, I'm off the grid, out of practice essentially until December. So of 22.
Okay.
So I'm out of pocket for about 9 months. So there are things which may have occurred before that, like, and I just don't remember if the arraignment had already occurred or not. I'm not sure, but I may have missed some things in that 9-month period when I'm on leave of absence.
Okay.
When I came back, I think arraignment, everything had already occurred, because I think we were already quickly moving towards trial calendar.
And were you already in conversation with the state during the time, even before you appeared back in court, regarding this case and your client? Before December 28, 2022.
I believe the sequence was in November. The state sent sort of a inquiry email, and I then contacted my client to firm up, hey, am I still your guy? Am I still your attorney? And are we going to be moving forward? And I think they also had to know, are you ready to come back?
Hey, who do you mean?
Well, my client. And I also had to make sure that, hey, I've passed all the tests, I've done everything necessary to be able to resume my practice. Everything fell into place. I did come back, and by December, I think, was when I started to communicate that, yes, I'm still his attorney, and we started to move forward with different things.
I'm showing you what has been marked as State's Exhibit 450 Yankee. Would you take a look at that? And Your Honor, it's the 450 Yankee you've identified previously.
Thank you.
Without reading into it, without reading it out loud, rather, would you please look at it and tell me if you recognize the document that I have placed before you that is labeled 450 Yankee?
I do.
All right. How do you recognize it?
This was an email that was sent to me, like I said, in November. And it was, when we receive a letter of this nature, it's sort of an inquiry.
Without getting into all of the details, is that an email that I sent to you on November 30th?
Yes.
All right. Is there an attachment to the email that is also a part of State's Exhibit 450 Yankee?
Yes.
All right. And did that attachment also make its way to you in that email on November 30th?
Yes.
Is that a fair and accurate copy of both the email and the attachment that you received from the state on November 30th, 2022?
Yes.
Your Honor, the state tender states 450 Yankee as evidence.
It's admitted.
Mr. Wright, would you please read the body of the email itself? And by the body, I'm talking about, yes.
Okay. Good afternoon, Attorney Wright. It's always good speaking with you. In the event that your client wishes to speak with the state, in this case, I have attached a standard proffer letter for your consideration. Please let me know if you can provide any further assistance. Adrian.
Now, looking at the proffer letter that is attached, all right. With the court's permission, I'd like to publish the proffer letter. It's a blank proffer letter, but it's a...
You may.
Thank you. And for the record, this will be pages 2. Are we signed into Zoom? Okay. Everybody has it.
You should be now.
Thank you. While we are pulling that up, with a simple yes or no, is a proffer letter the same thing as a plea agreement?
No.
All right. And is that distinction made within the proffer letter that you received?
The general language distinguishes between...
Scroll up to the first
or
page.
at least makes it clear that this is not in itself a plea agreement. This is really just an agreement to start having conversation between the state and the client.
Mr. Wright, are you able to see the first paragraph of the proffer letter that is before you on the screen? Can you see that? I have some readers if you don't.
No, I'm just trying to clear this audio box.
May I approach?
Yeah.
And
You may.
Okay.
Is that better?
Yeah,
Okay. Are you now able to see it?
I am.
All right. I don't want you to read the entire document that's in evidence, but would you please read into the record just that first paragraph, starting with "Dear Mr. Sledge."
Okay. If I just read off the letter itself.
That is fine.
Okay. Dear Mr. Sledge, the office of the Fulton County District Attorney, Atlanta Judicial Circuit, has been informed that you may wish to make a proffer for the purpose of providing information that you may have regarding the individual or individuals involved in the enterprise Young Slime Life hereinafter YSL, or otherwise have information regarding your own involvement. This is not a cooperation agreement or a plea agreement. The following terms will govern any proffer session with you.
Okay. Now, without going into each of the terms, was a requirement of the proffer agreement, and starting with this particular one, that Mr. Sledge actually sit down and have a conversation with you present, along with an investigator with the district attorney's office and a prosecutor from the district attorney's office.
Yes.
All right. And based on the request made on November 30th, 2022 to you, was Mr. Sledge's complete truthfulness and candor material conditions required in this proffer?
Yes.
All right. Did the proffer letter inform Mr. Sledge that if he knowingly withheld material information or willfully made false or misleading statements during the proffer, any statement made or other information provided during the proffer could be used against him in a subsequent proceeding against him for perjury, obstruction of justice, or making false statements to law enforcement?
The letter does give that notice.
Okay. Does the letter also inform your client that if he or any person acting on his behalf subsequently takes a position in any legal proceeding that is inconsistent with what is contained in the proffer, whether in pleadings, oral argument, witness testimony, documentary evidence, questioning of witnesses, or any other manner, the district attorney may use the statements in this proffer and all evidence obtained directly or indirectly in any argument and for cross-examination, impeachment, or rebuttal evidence?
It does say that.
All right. Barring those circumstances, was it your understanding that the proffer would be used against your client?
Generally, when we do a proffer, it's sort of a whatever you say, it's sort of a what a queen for a day. You get to say it.
Explain queen for a day to the jury.
You get to basically say whatever you're going to say and it not come smack you in the face, meaning it's not going to be used against you and hit you over the head with whatever you tell them. It's a way that the state evaluates the information that you have without you being in a position where, well, now that we've had this conversation, you're using it against me. Well, I never should have said anything to you.
No matter what type of severe asthma you have, Tespire can help you have fewer attacks.
Both sides be able to feel where the other side's coming from without anyone lessening their legal position.
And have you just described what your understanding of this proffer agreement or proffer request was?
Correct. Any proffer on state, federal, I sort of hold that general opinion.
Okay.
It's a case-by-case basis, whether it's good or bad.
So let's talk specifically about the language in this proffer. Does paragraph 2 of this proffer read, the office of the Fulton County District Attorney, herein after referred to the district attorney, requires complete truthful statements from you. Any statements made by you at this proffer cannot and will not be used against you in any grand jury proceedings or at trial against you in the district attorney's case in chief. No statement made by you during this proffer will be used against you to increase any future recommendation by the district attorney as to an appropriate sentence for you should you be charged in this matter. However, this agreement does not apply to any previous statements you made to law enforcement officers.
Your Honor,
Yes,
I'm going to object under relevance and also 403 waste of time.
Your Honor,
Yes.
as it relates to questions on cross-examination about whether or not a request was made to sit down and speak with Mr. Sledge and Mr. Sledge's answer, the contents of a request to sit down and speak with Mr. Sledge and the circumstances or the requirements are relevant for the jury to assess any information they hear from witnesses on the stand.
Okay, well, they've heard that occurred, so move on.
Thank you.
Sustained.
Thank you. Did your client agree to sit down with the state before entering into plea agreements with the state?
You know, I don't have any memory of us actually doing the proffer. I was going to ask you if you have a signed proffer agreement. That might help refresh my recollection. I remember receiving the proffer, at least the proffer letter. And then later on, we ended up in a plea negotiation. But I don't recall us actually executing the proffer process before that.
Do you recall any verbal communications with the state conveying that your client did not wish to give a proffer? Do you recall any?
Hang on.
Objection, Your Honor, leading, it's suggesting an answer.
I'm not suggesting an answer. It requires a yes or no answer, but it does not suggest one or the other.
Overruled.
Do you recall any verbal communications with the state?
Again, because I don't have any recollection of actually doing the proffer, I do not think that we were in a position that we accepted the invitation for a proffer. I also have a specific recollection that a few weeks later, I then, based on some things which were sort of happening with the case, reached out to you, knowing the proffer had been extended and knowing, okay, like to have some more discussion about maybe resolving this case.
Okay. Did any part of that involve your allowing or your client agreeing to sit down with me to have discussion before he entered into a plea agreement?
I just don't have a memory of having a conversation with you prior to the plea. So I at this point, I would say I just don't recall that. If it did occur, if you can refresh my recollection, but I don't recall there being a meeting between y'all.
If your client wanted to meet with the state, would you have arranged it?
Well, yeah, we certainly, if my client had expressed an interest, then I would, of course, it'd be my duty to follow up on that.
And would you have, based on your practice, would you have sent that via email? How would you have conveyed?
It may have been a phone call, but more than likely I would have emailed, so I would have had something in writing to confirm it. And if there had been such a meeting, there'd be a signed proffer letter because I would have wanted the protections of the proffer letter in place before that meeting. I wouldn't have put them in a meeting without a proffer.
Have you had an opportunity at my request to go through all the correspondence between you and the state as it relates to your client and this case? And let's stop there. Have you had an opportunity to go through your correspondence?
I have.
Is there any email, note, letter, designation from you that you were able to find that gives you any belief that your client at any point wanted to sit down and talk with the state?
No.
All right.
Fist of Fury, Fist of Fury, come on. Ah! Yes! Fist of Fury.
To conversations outside the presence of the jury, modify 460 as necessary, but as I'm going to show defense counsel 460, I would like to approach the witness after they've had an opportunity to look at 460.
Okay. Is 460 wide?
460 Yankee. Thank you, Judge. For the court's edification, we're reviewing the paper packet that I provided the court and defense yesterday.
All right, thank you.
Here's the thing, aging begins in your cells. Start supporting your cell health today.
Have I Got News for You is coming to CNN this fall. Pros and cons list.
Pro, hosted by Roy Wood Jr.
Pro, with Amber Ruffin.
Pro, with Mike.
Thank you. Thanks.
And I've labeled them 461 Yankee Court. I'll give it to the clerk. Permission to approach witness with 460 Yankee. Without reading out loud anything that's on 460 Yankee, do you recognize correspondence from you to the state contained in 460 Yankee?
I do.
And does that correspondence accurately reflect or contain the entirety of the correspondence that is listed within 460 Yankee that you sent to the state?
I believe so, yes.
As you reviewed the correspondence that you sent to the state at my request this weekend, did you find anything as it relates to this case in addition to what's contained in 460?
I did. Ultimately, what I was sending to you in that exhibit was some of the stuff I had found to make sure that I guess everyone was on the same page as to what our correspondence was.
And showing you 461 Yankee and 462 Yankee without talking about what they are those additional emails that you sent to the state in response to the state's request that you provide all the correspondence that you sent to the state regarding this case and your client?
Yes, this does look like an email that I sent, which was a compilation, same kind of thing, sending you old emails regarding this case.
Do you see anything between State's Exhibit 460 Yankee and 461 Yankee and 462 Yankee that is materially different from the correspondence you sent to the state regarding your client in this case?
I do not.
Do you see any difference, any omissions between what you actually sent to the state and what is contained in 460 Yankee, 461 Yankee, and 462 Yankee?
I do not.
Your Honor, I'm placing witness Winfrey 450, which is been admitted. now going to ask you if you would take a look at 451 Yankee, Your Honor, and this has already been labeled and provided to the court and to counsel. Would you just take a look at 451 Yankee? Does 451 Yankee accurately reflect correspondence sent from the state to you on December 27, 2022 at 4:57 p.m.?
Yes.
I'll hold that right here, okay? Looking at 452 Yankee. And when you look at it, after you've read it to yourself, would you tell the jury whether 452 Yankee accurately reflects correspondence sent from the state to you on December 27, 2022 at 5:06 p.m.?
It does.
You see any material alterations?
I do not.
Looking at 453 Yankee. Does 453 Yankee accurately reflect correspondence sent from the state to you on December 28th, that's Wednesday, December 28th, 2022 at 1:45 p.m. and that's 453 Yankee.
This appears to be an accurate copy.
Do you recognize or see any material alterations or deletions?
I do not.
Showing you 454 Yankee. Does 454 Yankee accurately reflect correspondence sent from the state to you on Wednesday, December 28, 2022 at 1:46 p.m.?
It does.
Showing you states 455 Yankee. Does 455 Yankee accurately reflect correspondence sent from the state to you Wednesday, December 28, 2022 at 1:54 p.m.?
It does.
And showing you what has been marked already as State's Exhibit 1AS. Do you recognize that as the agreement that was ultimately signed by you, your client, and a member of the state on December 28, 2022?
Yes.
And looking at State's Exhibit 444 Yankee, is that an identical version of 1AS?
It appears so.
Do you see any material alterations or deletions?
No.
Is the document that for the purposes of the hearing was labeled 1AS and for purposes of this trial was labeled 444 Yankee, was that document signed and agreed to before or after the documents that you just reviewed that have been labeled as 4 450 Yankee and 451 through 460 Yankee.
I'm sort of lost. Your question is, were the last two signed
No.
after receiving the other ones? That's why I'm not sure of your question.
All right. Thank you for that. All right. Are you agreeing that the...
Yes.
I'm going to object 403, police time, 401.
Your Honor, I believe that.
Overruled.
Your testimony is that 444 Yankee and 1AS are the exact same documents, so I can just use one?
Correct.
All right. So the document that is 1AS, was that signed after State's Exhibit 450 Yankee was transmitted to you?
Oh, let's not do them individually. Just ask the question again, and maybe he'll understand it the next time. It's just a time sequence, right?
It was.
Okay.
So, my question to you is, the document that is labeled 1AS, was that signed and agreed to before any of these documents that you just reviewed were transmitted? That's my question.
Okay. Let me answer it this way, because I want to make sure I'm on the same page.
How about asking for the clarification you need?
How about let him answer, and maybe he'll be able to answer what it is that you're trying to get at anyway.
The documents you've been showing me were all drafts of the plea agreement that were works in progress as we were proceeding. The first couple were the day before the plea. That's why they're in the evening. Then when we showed up to court that next day, while I think the format was y'all were in a conference room, I was in the back and shuffling back and forth, but you would email me and that way I would go over the different versions with my client. But what you just showed me were different versions which were evolving as we were getting closer to a plea agreement that we would execute and sign. The signed one, which is this 1AS, was the final version that ultimately got executed, that he signed, and you could see, I guess, with Judge Glanville, when we did the plea, that was the one executed. Ultimately, I have some concerns, but I'm acknowledging this is what we signed. This is what we ultimately did for the plea agreement, and the other renditions or iterations were showing the progress going from point A, where we had no agreement, to expressing what our concerns were, to getting an agreement hammered out. So all those were before this one.
Thank you. That was the only thing. Thank you.
Okay.
Did the state ever request to talk to your client without you?
No.
Did you ever offer up your client to talk to the state without you?
No.
Was the only way that the state communicated with your client through you?
Correct. Either through me or with me present, but not by himself.
At the point where December 28, 2022, where this case was soon to begin trial, were there options that you had in terms of going to trial, taking a plea, or asking for a continuance?
Again, let me answer it this way. I'm not trying to be difficult, but an explanation. legally, yes, we had options. We could go to trial or we could take a plea. Those things all in the very mundane, simplistic way, yes. But then as a practical way, my client didn't have the resources where he could hire me to conduct a year-plus trial. So those resources weren't there. So he also expressed other concerns he had unrelated to the trial. So you'd have to ask him as to what was going through his mind. But there are a lot of different factors that go into that. It's just not a simple yes, no. But yes, did we have different legal options he could choose? Yes. But why he made the choices he made, that's something you'd have to ask Mr. Sledge.
All right. And is it safe to say in here during the time that questions of those sorts were put upon Mr. Sledge?
Yes.
All right. And when you spoke about your client not having the resources to conduct a year-plus trial, did you ask to withdraw from the case at that point?
I did not. Ultimately, whether or not I would ask to withdraw and remove myself so he could either try to get appointed counsel or get new counsel, that would come after he makes a decision of what choice does he make among his different choices. Because he chose to go forward with the plea, then we never reach the issue of that.
And did you ask for a continuance at that point?
We did not. Well, I don't believe we did. However, I think I had been fully cleared to conduct trials, but I just want to say it might have been, it was right around that time frame. In fact, I think I had just finished a jury trial. So I think I was already cleared. So no, let me go back. We did not ask for a continuance.
And did you convey to the state certain things that your client simply could not agree to as it relates to some versions of iterations of the plea agreement?
Yes, we...
Without talking about what they were?
Understood.
Okay.
What I'm saying is we definitely discussed different things that based on where my client's position was, where the state's position was, some things we were able to work out as demonstrated in the different iterations, and then there were some things we could not.
And Mr. Wright, my question is, were there things that your client insisted, or that you insisted on behalf of your client, that the state changed in its final form? Were there things? I don't mind any explanation.
I'm going to say yes, and here's the explanation. Almost all the things we asked manifested itself in iteration number 3. That was the version before version 4, which is the one that ultimately got executed. So when we were looking at version 3, we saw everything and we're good to go. Version 4 introduced item number 8, which was not what he wanted.
And is version number 3 the one that is marked State's Exhibit 456 Yankee? And then 1AS. 1AS.
Yeah. Personal. No, this is not when I'm referring to version number 3.
Would you do me a favor? I'm going to give you all of the ones you just looked at.
Okay.
And would you identify by
Exhibit number.
Which one you're referring to as version number 3? I'm going to remove 456.
Your Honor, excuse me. Before the witness answers that question, do you mind if Mr. Shaw and I step up and take a look at the exhibits? We'll just not show that we have.
Sure, that's fine.
Which one would the court like for me to give to Your Honor, may I please remove them from Mr. Wright's possession? Let them confirm that these are the ones that they were given yesterday.
Yes, and then give them back. Yes.
Thank you.
Okay.
And if they have the ones,
I think it's more which one is which.
Okay. I did name them on the.
I know, but.
Your Honor.
Yes.
Excuse me. I appreciate that it's early in the day, but could we just have 5 minutes?
Let's take our morning recess while we do this.
Thank you.
Good idea.
I think it's 455. These are my
Oh, those are yours?
Yeah.
Okay. Your Honor, just so that the records are clear, if anyone from counsel from the defense could just bring the ones that they had up from yesterday, they could compare it, because I gave them numbers.
If they want to do that, sure, they can do that. I mean, I think these are the things that were originally sent over as electronic copies, and that maybe, and they were like a file within a file kind of thing. So that's probably what the complication is. Yes, you may.
Your Honor?
Yeah, and we're going to take a, yes.
I was going to, because they're going through the documents, and I shared with counsel for the state when she came up, the document I believe I was looking for is 455 Yankee.
Okay.
But I'll confirm it when I get them back.
Okay.
But that's the one that I think is the one that I'm looking for.
Okay, well, you'll get them back and we'll do that in front of the jury.
Yes, Judge.
I mean, you can certainly look through them, not in front of the jury, but we'll confirm whichever one it is once we've got the jury back. Okay, so we'll take like 15 minutes so that y'all can take a look and everybody who needs to can use the restroom. Yes, sir.
Another issue that one of the lawyers indicated that they were going to be speaking about.
May I ask if it pertains to these documents and this witness or something?
I think it, up at the bench, I think it was not these documents necessarily. Oh, yes, it was.
It's not these documents, the business records.
Yeah. It should be somewhere within one of those documents. So are you going to tender those for admission, or are you just going to have the witness talk about them?
At this point, not before I do the necessary redactions. I'm not going to tender anything. I'm going to ask him about these things right now. And as I said, I will not tender anything until I redact.
Okay, but I think there's an issue with regard to what ought to be redacted.
So we could, I don't mind.
Why don't y'all just talk? And then if y'all come to agreement, great. If not, then we'll take it up. So, 10:30, I'll plan to come back.
Okay.
Okay.
Okay. So as it relates, Your Honor, to what we discussed at the bench regarding State's Exhibit 460. And State's 460 is the paper copy of Mr. Sledge's email, Mr. Rice emails.
Right.
On the next to the last, the last page of State's 460. And Mr. Sharp is standing next to me, so if he has that, he could pull it up and confirm that I'm getting this part right. There was an issue at.
Look at yours.
You want to look at mine?
I don't. No. Continue. I was trying to interrupt. I don't have 460 printed out, so I'm just going to watch on.
Okay, go ahead.
Okay. So at the bench, there was an issue. Number 4, does the court have its copy?
I do.
All right. So there was no problem from counsel for the defense that actually voiced any concern about the first full sentence. The concern voiced by Mr. Adams, I think echoed by Mr. Sharp, was the second full sentence. And then they wanted to keep in the third and the fourth sentence. What I told them was that sentence, that number 4 was made in response to the email, and you can tell that from the time and date that it was sent. That was sent in response to the email that was sent to Mr. Wright, and that was dated December 27, 2022 at 5:06 p.m., which was State's 452 Yankee. The email that contains, and it may have been that we did include it twice. So Mr. Wright sent us an email on December 27, 2022 at 8:43 p.m. in response to the email that I sent to him that was subject Sledge Agreement Updated. And in that email, Mr. Wright enumerated 1 through 8 regarding factual acknowledgments. 452 is the email he was responding to that the state had sent. And number 4, yes. And so to the extent that the counsel for the defendants have all indicated during the break that they would like redacted from any prior iteration anything that was not included on the final State's 1AS, the final plea agreement, to the extent that number 4 on State's 452 Yankee gives context to that number 4 on State's 460, it would be necessary to be included to show that that was something that the state put on there that it believed to be true, that Mr. Sledge said no, and this was his response through his attorney.
Okay, so I'm confused now. On the different iterations that lead up to the final agreement, I understand that one of them is this number 4 that the state was proposing that he say
that he was saying
that he, Sledge, had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that
in response,
are you saying that the defense wants redacted the earlier version of number 4?
Yes.
You're on.
Yes.
Okay. I think we're going way down a rabbit hole here. The state seems to me, we don't need anything redacted if it's not being admitted into evidence.
Well, I think it is going to be admitted, or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant. I mean, if these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual, because it's not in fact what he ended up agreeing to.
I agree.
Yes.
Well, can I just
Yeah.
some things?
Okay.
Okay. First of all, I agree that Mr. Sledge said that. I also know that Mr. Wright and actually Mr. Sledge acknowledged that some things were changed, some things were not changed. So no one is claiming that nothing was changed. Okay? That's first. But secondly, I want Your Honor to understand, and I sought clarity from the state because I don't work for the state. I was not communicating with Mr. Sledge back then. These initial factual acknowledgments were in no way based on anything Mr. Sledge ever said to the state. The state came up with these factual acknowledgments from a review of the discovery and proposed these. So the genesis of these is purely divorced from anything Mr. Sledge stated. Okay? It's not, there's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgments, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state from looking at the discovery.
Okay.
So I would ask if we're going to let in basically incorrect information that Mr. Sledge has never agreed to, and we're going to expose the jury to this, I think we need to be a little stronger with the instructions and say these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
All right, I get your point. I get your point. And y'all, this is why I had us come a half an hour early, is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, etc. But so, Ms. Love, are you not in agreement with redacting things that didn't ultimately come into the final agreement?
Correct, for the reasons that the court earlier alluded to, and also... All
right, and you do realize that some of what might come in like this, if the version of number 4 comes in that is a proposal that YSL Associates were planning to murder Donovan Thomas Jr., that there are concerns with putting that type thing before the jury.
Well, I do want to hear the court. I do want to understand fully the concerns that all of them that exist. And ordinarily, I would simply leave it at this. Yes, I know there are concerns, but in as much as Mr. Sharp has indicated that, well, his version of reality, mine differs slightly, and I would not go so far as to characterize.
I'm not going to give an instruction that says this is not based on anything. Okay.
Well, can I just respond to that though? But if you're not going to give an instruction, Judge,
I am going to give an instruction.
I understand. But
if this even comes in.
This is the problem. If this comes in, I think the jury would want to know, well, where did the starting point come from? And the only way we could bring it to the jury, because I didn't really know until this morning, to be honest, where the starting point was. It's always been a question of mine, how did these even get the first version? Where did it come from? The only way we could really bring that to the jury is to call the drafter of the acknowledgments to the stand, who I assume is Ms. Love, and ask, well, these acknowledgments that you drafted, when did you draft them? Was it based on anything Mr. Sledge said, or was it based on the discovery? Because, and I'm being 100% forthright right here as an officer of the court, Your Honor. I've never been a prosecutor, but I was under the assumption that there was something that Mr. Sledge said that led to the first statements, and then it was like an editing process. But the first version was not based on anything Mr. Sledge said, and that's important, because the jury has to determine, okay, did the state just come up with these, or did Mr. Sledge say certain things and he's backing out of them now? And if we don't make it clear to them that Mr. Sledge was not the genesis of even the first version, I think that question becomes unanswered, and the only way other than an instruction would be to call Ms. Love to the stand.
All right, Ms. Love, what's your response to that?
Your Honor, one, again, the idea that this...
All right, I don't need
I'm not trying to
full-blown rehash of everything. What is your... Let me re-ask. What do you propose?
I propose that the court instruct the jury that it is to take as fact no information contained in any iteration of the plea agreement unless that assertion or that factual acknowledgement is in the final version to which Mr. Sledge...
Let me ask you this. Would you be able to get essentially the same information before the jury? And I believe the information you want before the jury is that very material things about the factual acknowledgments were changed at the request of Mr. Sledge and Mr. Wright. Is that essentially the point you want to make?
Blandly, yes. I think that I would rather ask Mr. Wright, did the state ask, because essentially that's what we're doing, because we couldn't sit down with him. Did the state ask your client if he had personal knowledge that the murder of Donovan Thomas was pre-planned by YSL members? Did we ask him that? And did, through you, your client tell us no? Did he say no? I believe that the shooting was...
he says he did not know.
Right.
He thinks it was not planned, but more impromptu, or at least very short or little planning.
Right. So we don't need all of that.
What's his basis for knowing that? I mean, that's part of their problem.
That it was impromptu with little planning? Well, because he was at the house with... If we're talking state's theory, because Mr. Sledge still has not met with us, but if we're talking what we believe, is that everybody was talking about it. They were at the house. We have more than one witness who says at Defendant Williams' condo, they met up. And
after the fact.
Yes, after the fact. And they talked about it. They talked about catching.
Okay. They could have talked about it and it never come out whether it was planned or not.
And based on the conversations, this is what I have gathered, based on the conversations that Mr. Sledge was privy to, his understanding was that it was not pre-planned. And that is the reason when he says what he does, that he says it. So we're not trying to get into what he thinks. We'd be sufficient with, did we ask him that? Did he tell us no? Did we at first have something to that effect?
So I think that's a lot safer way to go about it is, did we ask him that and did he say no? And did he leave it at that and not follow up on, here's what he thought instead?
I completely agree. But the part that I think
you said a minute ago.
Okay.
So
the part
go ahead.
The part that I'm concerned about and would like to also put before the jury was, and did we include that question as part of the factual acknowledgments initially? Is that something that he absolutely said no and refused to acknowledge and had insisted that we change?
All right. So it seems like if y'all, the defense, wants in portions of number 4 that maybe the sentence at issue could read, he thinks shooting Peanut was not planned, and then redact the remainder of it. because that shows that he is saying, no, what the state is asserting is not true to my knowledge or belief.
And if the court lets me leave Mr. Wright, I can say, did he tell us? No. Did we ask him, did he have personal knowledge as pre-planned? Did he tell us? No.
But if we're talking about how to redact 460Y if you tender it, then that would be, I think, a much safer redaction.
So taking out everything except he thinks the shooting was not planned?
No, taking out, leaving in everything except, but more impromptu or at least very short or little planning. Mr. Sharp.
Well, I just have concerns with the state. Here's the state can have their theories. Mr. Sledge on the stand has said no one talked about the murder. Okay, I mean, they talk about
at
Mr. Thomas. Yeah, at the condo. They talked about Mr. Thomas had passed, but no one was saying this is what happened. There was no discussion. So when you ask someone, if Mr. Steele asked me, hey, was that murder pre-planned? And I say no, then it insinuates, it gives the impression that I know about the murder. I have some information about the murder.
Yeah.
And that's my problem, is just saying that in a vacuum.
Okay. So how about, I mean, the beginning of what he says is really the answer. He said he did not know, and the rest of it is elaboration.
And Judge, the portion that was, let's see. Okay. So based on what Mr. Wright wrote back to me, we included a line that was not initially included in the previous iteration that I think is 452Y. Okay. And I think that line is number 8. And we drew the same exact conclusion number 8 of 1AS. Number 8 of the document that did get admitted, which is that defendant personally knows that one or more YSL associates committed the murder on behalf of YSL. So based on the response that we got from Mr. Wright, from Mr. Sledge, that was what we concluded too. And that is why we put in here number 8, which is different, and it may not be in the prior iterations, but as we went back and forth,
Okay. So, I mean,
Judge,
I think that it would be safer in terms of what gets put before the jury if you do this through question and answer with Mr. Wright. All right. Would you be, I mean, you let me know whether you're going to insist on tendering, but
I'm certainly not going to do anything the court says don't do.
Well, I'm not telling anybody how to try your case. That's not my job to do.
Understood. I'm not going to tender it before the lunchtime hour, at which point, if there is an issue that we need to hash out or I need to say.
Okay.
But at this point, I am very much intending to handle this verbally with Mr. Right on the stand, because I think it's something that I can do clean.
All right. Is that going to be true with regard to also not tendering the different versions, just talking about them?
Right now, yes.
Okay. Yes, sir.
Let me just point out that in regard, and just very briefly, because I don't want to, go back over everything we just discussed, but number 8, that's referenced by.
You're going to have to give me some. Number 8 on which?
1AS, the final iteration.
All right, I don't even have that in front of me, but I know it is. I just, there's a lot of evidence in this case.
It is,
and I only have 2 screens, so
give
me a second.
But I can orient the court if it helps.
If you'll just give me a second. Okay, that works too. All right. Go ahead.
So 1AS, Section 8 is the portion that Ms. Love just referred to, where she says that we changes to the document based on what Mr. Wright said back to us, and so we came up with 8.
Right.
Defendant personally knows. Well, if the court recalls, that is what they asked Mr. Sledge about when he was on the stand, and he specifically disavowed it. He said, no, that's not accurate. That's not true. And so if we go back to what we talked about earlier this morning at the bench, my simple request was just that, and I think we may have reached there. I kind of got lost a second ago. Is that in regards to them sending this iteration and Mr. Wright sending back the response that shows up in number 4, all right, number 4, where he says he said he did not know. That's the answer to the question. And I think that's where the court ended up. That's the only.
No, where the court ended up, and we talked about that yesterday, was he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was he doesn't know that.
Right, but what we discussed at the bench earlier, and the reason we asked for this portion, for that sentence, the sentences reads, he thinks shooting Peanut was not planned but more impromptu or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that
yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
But maybe I'm just not understanding, because I took the court's previous ruling and I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out. The court agreed, and we thought that that part was not going to be read to the jury or presented to the jury.
I don't think that part has changed.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
what he had said.
Right.
Yeah. Right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Ms. Love is going to somehow get from whatever it was he said, hang on.
Number 4, Mr. Wright's email.
If she thinks she can get from it was pre-planned, no, he didn't know that, he couldn't say that, to somehow that answer being the basis for putting in he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Ms. Love, you're the one that's putting them all into issue right now.
I'm putting them into issue to impeach what Mr. Slayer said regarding his regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with, and they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So how you deal with that is up to you, but
since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury. I am talking about this idea that the state.
Well, the easiest way to do that is, so what was it that you wanted changed that didn't get changed?
Right.
And then why is it that well, that would be speculative, but I just said I wasn't going to tell y'all how to try your case, but okay. So we are not at this point going to be admitting any of these.
We're not
just going to be
tendering them to-
discussing them with him.
At this point, correct.
All right. Yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Shart said, would you also go through an analysis of confrontation clause, because the statement now comes from a party opponent and it's used for litigation. It is a clear, to me, bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright.
Well,
Okay.
okay, I'm sorry. I thought you were
No.
finished.
Second part, and I apologize, I'll be very brief. Second part is a 403 analysis. You know, it's like saying, Ms. Love saying to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence, or in the presence of Mr. Harvey? And then Mr. Adams responds, no. You know, that's really bad for a jury. That is really bad. And that's really what's going on here. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity to Mr. Sledge through his counsel to make amendments? Answer, yes or no.
Mm-hmm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness because of the confrontation clause, and I think it's very prejudicial under 403.
Okay.
Your Honor, we've had the witness on the stand that made the statements, that signed them. We've inquired of him. He's
I
made
think that
some.
does take care of the confrontation clause issue. And with regard to 403, I mean, I agree. We've spent the whole morning on this, and let's target the questions to get to the cogent issue, which is, were they able to make material alterations upon request? All right.
Yes, Judge.
Okay. So we ready to get the witness back in and the jury back in? Yes.
It is cold in here.
I'm sorry.
I mean,
I have a heater that he can use if he's cold.
oh no, I mean,
So we don't turn it down.
I'll soldier through it. I'm just,
I can get my heater.
is it, I was just wondering, is it me? Or,
No, it's cold to
I'm
almost
good.
everybody except for the judge and the deputies.
And Ms.
And a couple of the jurors who are fanning themselves because they're too hot. And, but yes, it's not an ideal temperature for everybody.
No, I'm good. Thank you though. Yeah. Observer present, counsel.
Thank you. Go ahead. Thank you, Judge. Sorry, I'm trying to adjust the temperature a little bit.
Mr. Wright, I'm going to put in front of you states 1A as once more.
Okay.
And I'm also going to put in front of you states 452, Yankee. Are you able to discern, are you able to tell whether, and I'm putting in front of you states 460, Yankee, which has been admitted as evidence.
Okay.
And are you able to determine if 460 Yankee was sent in response to 452?
I don't know that that's been admitted. 450 was
452
admitted.
hasn't. I haven't.
No, I don't. Did you say 460 was admitted?
I believe, yes, 460 was.
And it hasn't.
It hasn't?
Only 450.
Okay. Your Honor, the state because it's okay. Without reading anything from 460, thank you, Judge. Without reading anything from 460, are you able to tell if 460, the last 2 pages, were sent in response to 452, Yankee?
I do not believe so.
Is there one or anything that you have a record of that occurred between when 452 Yankee was sent to you and 460 Yankee was sent from you?
Okay.
Without saying what it is, because we haven't entered anything as evidence, do you have a record of any correspondence that occurred in the middle?
The record would be in reviewing my emails and without going into the contents, there's what I saw and had on the 27th of December, and then what we were interfacing back and forth on the 28th when we were in court.
Do you, looking at 452 Yankee, is 452 Yankee, did you say earlier that that accurately reflects an email sent to you on December 27th?
I did. But I'm looking and thinking there were at least 4 versions, but there might have actually been a little bit more. But when I'm looking at what I thought was the first version, which is what I thought my response was to, it looks like this may have been an updated first version, meaning I'm just seeing some slight differences. That's why I'm hesitant to just say, yes, that this is it. I can't say, is this iteration that was in that process of getting us to the end? Yes.
All right. Are you able to say if there is any material change from the number 1 under the factual acknowledgement section from 452 to whatever version you're looking at that you think you might have been responding to?
To jump
just number 1 on the factual acknowledgments. Number 1.
Okay. Number ones are
Don't
one
say
is
what it is.
one is the same.
Okay. My only question relates to number 1.
Okay.
All right. And so as it relates to number 1 on the factual acknowledgments that you were responding to when you said 460Y, is that number 1 the same as in 452Y?
Yes.
Is that the same in the document that has been admitted as 1AS in a prior hearing?
Let me just to. Yes.
And is that the same as number 1 on State's Exhibit 444Y?
All right, we already established that 1AS and 444Y are the same document, so we don't need to ask that question for all of them.
All right. Did you convey in 460 Yankee that I have in my hand that you did have? Did you convey in an email to the state on December 27, 2022 at 8:43 p.m. that is a part of 460 Yankee? Did you convey changes that needed to be made to the plea agreement in the form that you were looking at, whichever one it is?
Yes.
Were those changes reflected in the document that is 1AS? And I don't need you to read it.
Yeah. No, I was going to say all except all the changes were ultimately incorporated. The only issue with the document 1AS is number 8.
Okay. So are there any changes that you saw need to request that you do not see reflected in 1AS? And they don't have to just be in States 460. Are there any changes in 1AS Are there any changes that you asked to be made that aren't made in 1AS? Material changes.
What I'll do is
number by number on.
Well, first with number 3, we indicated.
Wait, you cannot say what's in there. Okay. I just need you to roll.
No, number 3.
I don't know of any ruling that the court has made that says he can't indicate what the change that he requested being made. And that's what I understand that he was about to explain.
Your Honor, it's going to get into.
So the question was, are there any changes that were requested to 1AS that were not made? So he's entitled to answer that question.
Okay.
And if you want a full answer, we don't know what he's going to say. So
Yes,
is the final document
that question
got signed.
Right.
So given all of our discussions, Ms. Love was trying to be careful about So if you're objecting to Okay.
So, Mr. Wright, would you just follow along with me and let's do this exercise using only the numbers under the factual acknowledgement section in document 1AS. May we do that?
Yes.
All right.
So can I make a suggestion? 1AS is, or a version of it, 444Y is in evidence. Would it be beneficial to display it?
Your Honor, my understanding is it's not in evidence.
444Y is, and 1AS is the same document.
So
I don't.
Is it not?
I don't believe it is. And I.
Can we take a look?
Please do.
And Your Honor, if we can approach, I can explain. We already discussed this at the bench.
Okay. No, you're right. I remember. Okay, never mind.
Just same numbers.
Correct. If we could just use the numbers.
I would say.
And I'm going to address them one. Is that okay?
Sure.
All right. So, was there a material change as it relates to number 1 of 1AS that you requested that was not reflected in number 1 of 1AS?
No.
Is there a material change to to number 2 of 1AS under factual acknowledgments?
No.
That you requested that was not made?
No.
Is there a material change to number 3 of states 1AS under factual acknowledgments that you requested but was not made?
3, yes.
Okay. So we'll put that down. And we'll come back to it.
Mm-hmm.
Was there a material change to number 4 in states 1AS that you requested that was not made?
No.
All right. Was there a material change to number 5 in states 1AS under factual acknowledgments that you requested that was not made?
No.
That Mr. Sledge requested that was not made?
No.
Right. Was there a material change to number 6 of States Exhibit 1AS under factual acknowledgments that Mr. Sledge requested through you that was not made?
No.
Was there a material change to number 7 under factual acknowledgments as reflected in States 1AS that Mr. Sledge requested that were not reflected in number 7 on 1AS?
No.
Can you just say same question for number 7, same question for number 8?
Okay. Okay. Same question for number 8, and if I think number 8
Yes.
wasn't on a prior.
And yes, but and again, it wasn't on a prior edition, but it
Was on the
added to
last
this one.
edition.
So, but
So
the
I can't.
subject matter was one of the things we said.
Okay. So, Your Honor, I can't ask the same question for, okay. All right. Number 9, was there a material change regarding number 9 that was requested by Mr. Sledge through you that is not reflected in number 9 under factual acknowledgments of States 1AS?
No.
Is there a material change to number 10 on States 1AS under factual acknowledgments requested by Mr. Sledge that was not made on the final document?
No.
Same question for number 11.
No.
Same question for number 12.
No.
Same question for number 13.
No.
Same question for number 14.
No.
Number 15, same question.
No.
Number 16, same question.
No.
All right. As to the sentencing acknowledgments that are reflected in States 1AS under Section 5, did you review those? Are you comfortable telling the jury whether or not you went over those sentencing acknowledgments with your client? Just yes or no before you explain anything.
I would have went over the entire agreement, including that section, yes.
Okay. Did you allow your client an opportunity to ask any questions that he needed to ask?
Yes.
Did you restrict his ability to ask you questions?
No.
All right. Based on your knowledge of over 15 years of interacting with your client, did your client appear comfortable asking you anything he wanted to ask you?
Yes.
Did you answer your client's questions as thoroughly as you could possibly do in your capacity as his attorney?
Yes.
Did you answer them in a way that, based on your 15-year knowledge of him, you believed he fully understood?
I hesitate. My answer would be yes, but again, I'm not a mind reader. So other than perceiving his responses to me and that he seemed comfortable, I can't purport to say what all is going through his mind.
I didn't ask you that.
Yeah.
I appreciate your response. I appreciate your clarification. So I asked the question I did for a reason. Based on your 15 years of knowing him, did he give you any indication that he did not understand any one or more of the provisions under number 5, sentencing acknowledgments, which are in 1AS?
No.
And when you said yesterday that you had represented Mr. Sledge in 2 cases over the last 15 years that were felonies and one that was a misdemeanor, would you explain like what it is, how you're able to determine when he doesn't understand something as it relates to a plea, and how you're able to determine when he does understand something? What does he do when he doesn't understand something?
Well,
Your Honor, I'm going. Same objection.
Sustained.
How do you decide that something needs more clarification when you're interacting with Mr. Sledge?
With Mr. Sledge or any other client,
I just need Mr. Sledge.
Well, the point is I'm going to state what's, I guess, in front of us in terms of what any particular paper is going to say. Make sure that it appears to me that he understands it. Give him an opportunity to ask any questions if he doesn't understand it. And then in a document such as this where he's going to initial, that's just another way of him indicating that he has seen it, he's had an opportunity to discuss it with me, and he doesn't have any questions that we need to address to the court or follow up.
Okay. And do you pay attention to body language when you're asking him if he understands something?
Yes.
Do you pay attention to pauses or hesitations when he responds in order to determine if he just doesn't want to say it or if he really understands it?
I don't speculate and go that far.
Yes.
I'm trying to get a direct response so that I know how to proceed. But I understand your question, but I'm saying I generally am not going to try to surmise based on just body language. If there's something that creates a red flag for me, then I'm going to follow up with a question.
Your Honor, I'm going to ask a question that's going to harken back to something yesterday. It's going to sound not relevant. I ask the court's indulgence for a moment for me to ask this question. You remember yesterday when you were telling the jury that a particular question sounded like a hot topic, and I asked you, what did you see from me that made you think it was a hot topic?
Understood.
Okay? So when you're talking to your client, what do you look for to see or make you feel like he does understand something?
I'm listening.
Object. I believe that question has actually been asked and answered.
Sustained.
Are there nonverbal cues that you look for to see whether or not your client understands something?
I would say yes. I mean, I'm looking at their facial expression. Do they seem to be very clear on what we're discussing, what the topic is, what their response is, and obviously, if the client is very emotional, that's the more obvious. But I'm just trying to make sure: have you heard it? Do you understand it? And what is your answer? And then ultimately, we go from there.
Have there been instances during this plea or any other with Mr. Sledge where he's asked you the meaning of certain words that he did not understand?
I don't have a specific recollection of him asking about the definition of a word. However, anytime he had a question about the content of a statement or what that means, he did not hesitate to ask me.
Okay. Did you take care to explain what you would consider legalese or legal terms to Mr. Sledge that you thought he may have a problem understanding?
Anything that is of a legal effect, legal character, I'm going to make sure he understands in very plain terms, him or any client, what that means.
Did you go over each one of the 6 sentencing acknowledgments, both before and at the time that Mr. Sledge signed or initialed the 6 sentencing acknowledgments in States 1AS?
Yes.
And what about the last paragraph underneath that 6th sentencing acknowledgement? Did you go over that with him before and at the time that Mr. Sledge signed the document that is labeled 1AS?
Yes.
All right. Is there anything you haven't talked about that you now can think of that makes you feel in any way there was something he didn't understand?
Objection calls for speculation.
Sustained.
All right, let's go past that. Thank you, Judge. When you signed States 1AS, was it at the same time that Mr. Sledge put his signature above yours?
It would have been immediately after, yes.
All right. And on the same date that it was signed by the DA? By the assistant district attorney that is indicated?
Usually he'll sign it, I'll sign it, then I'll present it to you, and then get your signature.
Okay. Was there any material addition that you asked to be included in State's Exhibit 1AS that the state refused to include?
There was no addition, no.
Okay.
Or rather, let me say it this way, no addition that we asked.
Okay.
That was not included.
Okay. Was there something you requested be taken out of the plea agreement that is a part of States 1AS? And I stopped that question right there for a reason. Is there something you requested be taken out?
Yes.
And is it contained within a number?
Number 8.
Okay. And at what point did you request that number 8 be taken out?
Even in the very beginning in my initial email, we were given an indication that he did not have information.
Wait a minute, you're getting into it. I'm asking you about a time frame, just the time frame, because of
from the very beginning.
Okay.
That was one of the things that was an issue for us.
Was number 8 included in any previous iteration
I would
before States 4? Based on your notes, what iteration did the date and time that number 8 first appeared in?
Well,
based on your notes, and without saying what number 8 is.
Understand. And let me work my way backwards. I'm going to look through the earlier iterations, but I can tell you the one before this exhibit, which for my records was iteration number 3. It was not in there. So the subject matter of number 8 had been removed from earlier versions, was not present in iteration number 3, such that it appeared again in iteration 4.
And so would you tell me, or the jury rather, what iteration between states 450 and states 456. And including states 452. What iteration of that agreement did number 8 first appear in? Just by date and time and exhibit number. If it's in there.
Okay. It was not in 451Y.
Do you understand the question I'm asking?
Well, no, I am. I'm sorry. I'm answering in a way where
so
iteration by iteration, I'll be able to say if it appears at all. I do not believe it appeared in any prior iteration in that form, but I'm looking to just make sure the subject matter, if it did, I can answer your question and say it appeared in this.
If you find it, then point it out, but otherwise, just reach yourself.
Okay. In 452Y, number 4, the subject matter of that appears. It does not appear in 454Y.
Just if you see it.
It appears in 456Y, also number 8.
Okay.
And I had skipped over 455Y, but it does not appear in 455Y.
So, as you read over and initialed 18S with your client, I'll take these.
Yes.
Did you ever speak to the state about number 8? To the best of your recollection, did you request that number 8 be removed?
No, I did not. I have no recollection of seeing number 8. I understand my client initialed it because I can see his initial. I also understand it may have been enunciated by the state at the plea, but where we went from 455Y, where it was not in there, and then it was in there, I don't know how it got there or how we missed it, because neither my client or I appeared to have realized it was there, and it came in.
Are you saying that you did not read this document before you all signed it?
No, we read it and signed it. I can't dispute that. But how that number, when that was something from the very beginning we were contesting, I can only say we missed it, and it's in there.
All right. And when you say you were contesting it, how did you contest it? Without saying what you said, but how did you contest it?
Well, by telling the state that that information, that's the subject matter of that, is not something that he has knowledge of or information on. So I'm sort of hamstrung to answer your question.
All right, we'll come back. And so at the time that this document was being read into the record, were you paying attention?
I was paying attention, but I missed it. So apparently not good enough. Just as when I went over it with my client, which I did. I'm not saying I didn't, but that is something that to this, I mean, it sort of was a surprise of this trial for me, was that was in there, and how did we miss it?
And when you speak of that was a subject matter, beyond it being something you referenced in, you said it was, you saw it in referenced in 452 Yankee number 4, and you saw it in 456 Yankee as number 8, the final iteration. Is that fair? Did I get
Correct.
that right? Okay. Do you have notes, or do you have an email or a text message or anything that reflects, hey, 456 or number 8 on this document, not the final, but number 8, take it out?
To answer your question, going back to when this was happening, when we saw 455, it was not in there, and everything seemed consistent with what we had asked. When we were handed 456, I think we must have assumed, and I don't want to speak for Mr. Sledge, well, that 455 was what was being handed to us to execute. And we did not notice because, again, it's an addition. It's a completely different sort of addition, and it's in there. And again, I'm not disputing it is in there, but I can't explain to you how we missed what we thought we were signing, or what I thought we were signing was 455, not 456, with that additional number 8 embedded in the factual allegations. And I don't have an acceptable explanation as to how we missed it.
Okay, so looking at 455, and Your Honor, this is one of the last 3 questions that I have. Looking at 455, is 455 Yankee number 8 what you're referring to when you said that you thought 455 Yankee was the last iteration?
Correct. And I'm not going to go into it, but the subject matter of number 8 in this is different than what number 8 in 456 is.
And so is 455 Yankee number 8 what you were trying to agree to?
Yes.
Okay. All right. And does 455 Yankee have 13? How many factual acknowledgments are in 455 Yankee?
15.
And are there 16 in State's Exhibit 1AS? Here you go.
Yes, there's 16 in 1AS.
And beyond was there anything in particular about number 8 on 1AS that you brought to the state's attention at any time before now?
In the very beginning when, without going into the subject matter,
You can give me just date and time if there's an email you're referring to.
on December 27th, the email at 8:43, item 4
Okay.
was related to the subject matter of item 8.
Did you respond specifically to item number 4? I mean, did you respond specifically to item number 8 when you wrote item number 4?
Hold on one second. I'm looking for the iteration I had when we sent those responses. It may be. If you could hand me, I guess, the first version or first updated version, then, because I think I've got my stuff intertwined now.
Okay.
But what I was going to say, because I was going to reference what the subject matter of number 4 is.
You can't do that. Right?
Well, not out loud, but what I was going to say is, yes, it's the same subject matter.
And were you speaking specifically to a number 4 in a previous iteration when you wrote and responded to number 4?
Correct.
All right. Your Honor, thank you. I think that's all that I have for the witness right now.
All right. Cross-examination.
Your Honor, for the record, I'm just putting 1AS back with Ms.
All right.
Winfrey, and I'm taking back the ones that were not admitted.
Thank you.
You're welcome. This is not.
Okay. I think that's it.
No, you're all good. Good morning, Attorney Wright.
Good morning.
I believe we met briefly to introduce myself yesterday or the day before, but again, I'm Doug Weinstein, and I am Diamante Kendrick's attorney.
Yes, sir.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
You do not.
Okay. We talked about proffer sessions, and a proffer session, again, I believe you said, is when a defendant meets with the state, correct?
Correct.
So to avoid legalese, I'm just going to talk about meeting with the state instead of using that word proffer. Okay?
Yes, sir.
All right. So if there would have been a meeting between Mr. Sledge and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. Sledge and Attorney Love before December 27th?
No, not that I have any recollection of, and I was, I never want to give an incorrect answer, so I was cautious, but I don't believe we ever actually sat down for a proffer.
Was there a meeting between a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No.
Was there a meeting between Mr. Sledge and any member of the district, any attorney in the district attorney's office before the 27th of December?
Not that I'm aware of, no.
What about an investigator with the attorney's office?
No.
I have a slight objection just as to clarification because I'd ask that the meeting part based on other interactions, just vague. Was there any meeting?
The objection is vague.
Okay, let me clarify. When I have used the word meeting, what I mean is a proffer session. So to all of those questions, if I had used the word proffer session, were there proffer sessions?
I'm not aware of any proffer session that was ever conducted or even a more informal interview with anyone from the DA's office or law enforcement as it relates to this case.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgments, correct?
Yes.
So how in the world, to your knowledge, did the state come up with those factual acknowledgments for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to how the state did something or came up with something.
Overruled.
I believe the state was trying to surmise through its overall investigation.
Well, now, he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual problems.
So you don't know how the state put those words in your client's mouth?
I do.
As to the characterization
Sustained.
Okay. How many plea negotiations have you conducted in your career?
Definitely over 1,000, maybe 1 to 2 or 1 to 3,000 over 30 years.
Okay. And these plea negotiations are like any other negotiation that takes place between parties, correct?
Absolutely.
There are things that you want in the final agreement, right?
Yes.
They're the things the state wants in the final agreement, correct?
Yes.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
All right. Does anybody else have questions from the defense?
Your Honor, I have a motion as to part of that, but I'll ask it at the time that we break.
Okay. Mr. Adams.
Yes, thank you. Attorney Wright, good morning, sir.
Good morning, sir.
Like Mr. Weinstein, you and I have known each other a long time, haven't we?
Yes, sir.
All right. Got a number of questions for you, and I want to break them down into separate parts, okay?
Okay.
And same ground rules. If you can't hear me, you don't understand the question, just ask me to repeat myself, clarify, whatever you need, and I'll be happy to do that.
Understood.
All right. Let me kind of start where Mr. Weinstein left off. Proffer session has been a reference, which is a meeting between your side, you and your client, and the district attorney's office. Never happened. True?
Correct.
Sustained.
All right. You did receive, as we've seen previously, that email with the proffer agreement attached. Is that right?
Objection asked and answered.
I did.
Sustained.
You have never seen, never received, and there is no signed proffer agreement.
Objection asked and
anywhere,
answered.
is there?
Sustained.
And your interest in representing Mr. Sledge would have been to try and gain whatever the best situation was for him. Isn't that true?
Objection vague and relevance.
Overruled.
Absolutely. In anything, the best interest of my client, that is tantamount. That is the absolute goal. I want not just keep them home, not just some things you might think. I want the best possible solution for the case.
In this case, in representing Mr. Sledge, you indicated you'd known him for well over 15 years, true?
Yes.
And at the time that you came into this case, you were aware of the indictment and exactly what he was charged with in the indictment.
Yes.
You knew that he was charged with one count of RICO, or violating the racketeering in the RICO Act.
Yes.
You knew that he was charged in count 30 of the indictment with possession of a firearm by a convicted felon.
I did.
The count 30, the possession of a firearm by a convicted felon, is something that he was accused of. The allegation was that he committed that offense in December of 2021. Is that right?
Yes.
Right, and that was included in the overall indictment with the RICO count. True?
Yes.
Okay. Having represented Mr. Sledge before, you knew not just him, but you knew his family as well.
Yes.
You knew his mother.
Yes.
And so when you were in court over the course of the last number of days, and you heard testimony and questions about him wanting to get home to his sick mother, is it in fact true that his mother was ill?
Yes. I have personal knowledge that at the time we were going over this stuff, that was something he expressed and was stressed over.
That was a concern of his?
Yes.
You knew, and I want to kind of reference some dates. He was arrested somewhere in June, around June of 2022. Is that right?
I'm relying to some extent, but I'll say to the best of my knowledge, yes.
Well, you know that the case was indicted. The indictment was handed down in May of 2022.
Actually, that being the case, yes. He was arrested not long after.
Okay. You, and I don't want to delve too deeply into it, but you shared that at least in the early part of that, you were having some health concerns yourself.
Yes, and let me back up a little. The reason I paused on my answer was, remember, there was sort of an earlier part where he at some point had charges related to this. Those charges ultimately went away. Then much later on, there was an indictment and then an arrest. That's why I sort of paused, because that earlier date is not immediately known to me. But as to once this case was indicted, then the arrest, even though I was not back to my practice yet, I was aware of it and was sort of watching from the sidelines.
Okay. You were in court and heard when he was testifying about that previous matter you're referencing. In other words, his arrest and where he was charged with the murder of Donovan Thomas.
Correct.
And so at the time that you come into this in 2022, you have knowledge that detectives with the Atlanta Police Department had previously charged him with Donovan Thomas's murder and then ended up dismissing it, or dismissing the charges, right?
Objection relevance.
Goes to his
Overruled.
Yes, that's the point. I was aware from before, so when this occurred, it wasn't necessarily something new to me. I was already aware that there was some history.
Okay. You mentioned a couple dates when you were testifying earlier. We talked about you getting into the case somewhere around October or November of 2022. Is that about right? And when I say get into the case, when you were healthy enough, right,
correct,
to kind of resume your practice and get into Mr. Sledge's case.
Yes, sir.
Okay. By the time you would have interacted with him or started representing him on this case in either October or November of 2022, he would have been in jail for a number of months, true?
Correct.
He would have been in jail at the Fulton County Jail, true?
Correct.
And since he was in jail at the Fulton County Jail, that presupposes, and you know, that he did not have a bond.
Correct.
Now, if you're in jail and you don't have a bond, you stay in jail, true?
Correct.
The only way you get out of jail, if you're in jail without a bond, is you either, your case gets dismissed, right?
Correct.
Or you negotiate some sort of plea or deal that gets you out of jail, right?
Correct.
Or you go to trial and you get acquitted, and that gets you out of jail.
Correct.
Mr. Sledge wanted to get out of jail.
Yes.
He had been in jail for a number of months by the time you spoke to him, and he was anxious about getting out of jail, wasn't he?
Objection, Your Honor, asked, answered, and
Sustained.
He discussed with you his desire to get out of jail, true?
Objection, asked, answered, and it gets into...
Attorney-client privilege.
Yes.
Sustained.
Were you attempting to get him out of jail?
Yes.
All right. Now, Mr. Sledge, you were in court previously when there was some discussion about what an offered plea is. Is that right?
Yes.
All right. Now, and one of the ways that a defendant, even Mr. Sledge, could resolve a criminal case is with what's called an offered plea, right?
Yes.
Now, an offered plea, as you would have discussed with Mr. Sledge in one of his previous cases, revolves around someone saying, I'm not guilty of the charge, but I'm going to plead guilty because it's in my best interest. Is that right?
Correct.
Right. And you would agree with me that entering a plea of guilty, whether it's under offered or just a straight guilty plea, can sometimes be in a person's best interest, right?
Oh, absolutely.
And that may sometimes be regardless of whether they consider themselves to be guilty of the offense or not.
Objection, Your Honor, relevance.
Correct.
Oh.
Correct.
Because as you've testified previously, people enter pleas for different reasons. Isn't that right?
Correct.
You having, were you the one who did Mr. Sledge's bond hearing, or was it another attorney?
It was probably me. I just don't have it was a while ago. So.
Okay. It was in late 2022. True?
Well, you know what? No. His arrest on this, I wouldn't have been able to do the bond hearing. So I'm not sure who represented him for the bond hearing as it relates to that June arrest.
Okay.
I was thinking of the old case, but as to that, I would have to say no, I was still on the sidelines where I wasn't cleared to practice yet.
Right. One thing that you became aware of, though, when you came onto the case in late 2022 is that, as you indicated before, Mr. Sledge did not have the resources to go to trial.
Correct.
And it is true, as he testified. Did you hear his testimony about that?
I did.
And did you testify also earlier that you knew that he had limited resources and he just didn't have the resources to take this case to a year-plus trial, right?
It was something that was heavy on my mind in terms of when I'd be able to return to practice, to be able to assist Mr. Sledge, because knowing he had limited resources. And even, I guess, because of the relationship over the years, even though he didn't have the resources I would have liked to become involved in this case, I was going to do what I needed to do to help him. And therefore, even though it wasn't, a huge fee for, or resources for a big year plus whatever kind of trial, I wanted to get involved, make sure I'm here to get him out of this situation and help him in this case. So I know that was a long answer to your question, but yes, it was something actually heavy on my mind, which made me say, let me get back, be healthy and effective in making sure I can represent him.
One of the things that you would have discussed with your client, with Mr. Sledge, would have been the risks of going to trial. Is that right?
Yes.
That is certainly something that you would have counseled him to consider in regards to what decision he made. True?
Yeah, every client, we're going to have that conversation.
It is true that you would have counseled him that, hey, look, Mr. Sledge.
Objection, Your Honor, when it gets into specifics of the risks that Mr. Wright considered existed in this case. I think that is privileged information unless now Mr. Sledge has waived.
All right. Well, Mr. Wright understands the obligations of the attorney-client privilege, so please do not reveal any attorney-client privileged information.
And I was going to say, I cannot answer that question because you're asking me something specific to Mr. Sledge.
Sure. What you knew, though, is that had he gone to trial and been convicted, he would have been facing a potentially long period of time in prison.
I would say I would know for any of my clients that when you're facing these kind of charges, the potential consequence of a conviction could be a very lengthy sentence. So it's extremely serious. So you want to make sure you can stand guard and do the best to make sure you get the best result for your client.
And that is something that you would, without going into any specifics, that is something that is a factor that you would have discussed with Mr. Sledge. True?
Again, not specific to Mr. Sledge, but to all my clients, to make sure that their eyes wide open. We talk about the good, the bad, all the possibilities, so that you can make sure as an attorney that my clients have a full understanding of the risk, the reward, and all the possibilities in between, so that they make an informed decision on what they want to do.
You were aware, were you not, that the state, the district attorney's office, was interested in whether or not your client would testify, would take a plea and testify? You knew that, didn't you?
Yes, as of, I think the first email was sometime in November, when sort of the first communication that sort of gave us an idea that they would like to talk to him.
Were you ever present in court where any representations were made by an assistant DA that we're looking to make deals?
I first appeared in court in middle of December. That's sort of when I came back, but I also appeared on behalf of Mr. Sledge. I don't remember the details of what occurred that day, but I will say when I reached out to the state to say, hey, let's talk, it was middle of December. So it was after, I think, that first couple court appearances in December.
Okay. It would have been after, also, there was that November 30th correspondence between you and the state. True?
Correct. I had not yet responded to them, but it was in middle of December that I essentially was now responding to them and saying, okay, well, let's talk.
And that November 30th email was an email that you received from the state. Mm-hmm. It was unsolicited, true?
It's easy when you have emails to say, I remember this. It may have been a phone call where it is customary that even though you may see us in court, everyone seems to be one side or the other arguing. Professionals, we call each other, we talk, we communicate about different cases we may have going on. So it was not unusual for Ms. Love or someone from her office to just reach out, call me, as sort of that first step. And I think there might have been a phone call followed by that email. But again, I just don't have a recollection of a phone call or what the conversation is, but it wouldn't have been unusual. I've known Ms. Love probably 10, 12, also maybe 15 years. Okay. So as one professional to another, it would not be unusual for her to reach out to me to basically see, is my client interested in something?
Now, during that period of time, from November 30th to whenever it was you reached out to the DA's office, or had some conversations with them, you would have been talking to your client about what he wanted to do in regards to resolving the case, true?
Can you
move back towards the mic, if you don't mind?
Yeah, with all my clients, I'm going to communicate to them, hey, here are communications or statements or developments, anything about their case. So again, not talking specific with Mr. Sledge conversations, it is my norm and usual that if the state reached out to me, I would have made sure to reach out to him. And more often than not, I don't like jail phones, so I don't want to be listened to. So I will try to go see my clients and have that conversation.
At the jail?
At the jail.
I want to backtrack a little bit and ask you, you testified just a moment ago that you weren't sure as to whether or not you represented Mr. Sledge at the bond hearing in regards to this case. Is that true?
Yeah, I just don't have a memory. I may have, but I may not have. I just don't want to misstate something.
Would it help to refresh your recollection about whether or not you represented him at the bond hearing if I were to show you a document?
Absolutely.
Can I first witness, Your Honor? Yeah.
Yes, please.
I'm going to show you for purposes of the record what I've marked as defendants Williams Exhibit 257A and 257B respectively. I'm going to go ahead and put those to you, let you take a look at them, Mr. Wright, and once you're done, you just tell me whether or not that helps to refresh your recollection as to whether, as to who represented Mr. Sledge at the bond hearing in this case.
Yes.
Okay.
Seeing this, it does refresh my recollection.
Okay. So tell me if you would, whether or not you did in fact represent Mr. Sledge at the bond hearing in this case.
I definitely filed for bond, and I either represented him myself or I had someone stand in for me if there was an actual hearing, because I'm not sure in that time frame that I had filed for it whether I had been cleared. So I can at least state I filed for it and I either was there and represented him or I had an attorney stand in my place.
When the bond was denied.
So it's still on me, yes.
Okay. All right. So let's jump back to December now, right?
Okay.
So we're in December, and if I heard you correctly, the state has sent you an email on November 30th, and so now you're talking to your client in mid-December to see what he wants to do in regards to the case.
Okay.
All right. At some point, you end up in court, and I'm focusing now on December 27th, December 28th.
Okay.
Because the plea was entered on December 28th, true?
Correct.
All right. The correspondences that were shown to you, well, we've been using the word iterations of this so-called plea agreement. The first one came to you on December the 27th, isn't that right?
Yes.
And so the very first time that you and or Mr. Sledge would have had an occasion to consider the state's proffered plea agreement was one day before he entered his plea. True?
Yes, and to give you detail, that day, I actually, once I received it, went to see him to go over it. And then ultimately, it's when I got back that I sent the response. So that's why you can see I received it around 5 or so in the evening. I didn't respond until about 8 or so at night because I needed to basically go talk to him and get his feedback. And ultimately, I then sent feedback back to the state.
All right. So we're talking now about maybe 4 or 5 o'clock p.m. on the evening of the 27th. Is when you first received from the state this plea agreement that they had drafted up, right?
Correct. That the first one, yeah.
Right. And again, this plea agreement that they sent to you with the different paragraphs and provisions was something created by them, not by Mr.
Your
Sledge.
Honor, asked and answered. Sustained.
And when you went to the jail to meet with Mr. Sledge on the 27th, this would have been the first time that he had any opportunity to look at anything called a plea agreement. True?
Correct.
You would have discussed this plea agreement with him. True?
Well, again, not specific communications with Mr. Sledge, but with all my clients, I'm going to take the plea agreement and go over it with them. So any meeting where a plea is ultimately in the air and being discussed, that yes, I'm going to go get my client's feedback.
So by the time you see him on the evening of December the 27th, 2022, you've got a plea agreement with you, and you're going to have a conversation with him about whether he wants to take this plea, right?
Correct.
Okay. There's still, of course, the option of him going to trial. True?
That remains an option unless and until he takes the plea.
But hanging in the air at that time, with the plea agreement on one side and potential trial on the other side, was his concern about getting out of jail to see about his sick mother. True?
Objection
Yes.
answered.
Sustained.
Also hanging in the air was the possibility of him not having the resources to go to trial.
Objection
right?
answered.
And as you would do with any client, you'd have discussed whether or not there were things in that plea agreement that the client simply could not agree to or would not agree to.
Objection
Sure.
asked and answered.
I would say, again, not specific to Mr. Sledge, but when a client reviews a plea agreement, if there are factual allegations, because there's not always factual allegations in the plea agreement, but if there are, we're going to go over those. And if we go over those and there's some disagreement or there's some need for clarification, that's something that I will go to the state and indicate, hey, there's some issues here. We need clarification or changes or what have you so that we can make sure these are accurate.
And in this case, you actually did that, didn't you?
I did send an email to the state indicating that there are some clarifications that we would like.
Okay. So there's some negotiations now going on, or some correspondences, communications going on back and forth between you and the state, you on behalf of Mrs. Sledge and the state.
Yes.
From the 27th of December, carrying into the 28th of December, the next day.
Yes.
Sure? The next day, he's actually in court.
Yes.
He's brought into court, and you have an opportunity to talk to him in, a holding cell, a holding area? Outside?
Yes.
Okay.
He's in a holding area. And it's typical a lot of times that the client will be one place, the state may be in here or in a conference room, and I'm sort of the messenger of sort, going back and forth to help facilitate a negotiation.
You had the opportunity to discuss with the state that there was a factual allegation in their plea agreement that you did not want, or you wanted changed. Remember that?
Correct.
You talked about number 3.
Correct.
Now, the subject matter of that number 3 revolved around
Your Honor, I object as to the characterization of the number 3, and I'd object based on vagueness. Are we talking number 3 in 1AS or number 3 on one of the other exhibits?
Sustained.
All right.
Talking about the final version.
Yes. Let's reference what ends up being the final version of the plea agreement. I believe that's states 1AS. Okay.
Okay.
Do you have those in front of you? I want you to be able to refer to them.
I do not have that in front of me.
Okay.
Okay. My first witness.
You may.
All right. Mr. Wright, I'm going to give you what's been marked as states 1AS.
Mm-hmm.
And I've got some questions I'm going to ask you referring to that document, okay?
Okay.
You had a chance to see what would ultimately become States 1AS and the conditions, the provisions, the factual acknowledgments that were part of that document, true?
Yes.
Okay. Prior to the execution of that document on the 28th of December in court, you had an opportunity to communicate with the state that you had a problem, or y'all had, to use your words, some concerns about that factual acknowledgement, right?
Yes.
Now, that factual acknowledgement revolves around this incident about a video where Mr. Sledge was alleged to have been in a video holding a gun, making threats to someone else, to another person, correct?
Correct.
When the state presented any of the iterations, including that last one, right, of the plea agreement, they wanted Mr. Sledge.
Objection as to what the state wanted.
The factual acknowledgement revolved around Mr. Sledge acknowledging that while associated with YSL and to support and express loyalty to YSL, the defendant, that would be Mr. Sledge, and co-defendant Demikian Garlington and Quindarius Zachary appeared in the video with another person. AS, wherein defendant brandished a weapon used in a drive-by shooting and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, girlfriend. That was the factual acknowledgement, correct?
That was the factual acknowledgement, yes.
You communicated with the state and you requested that they change that, correct? Or that it be removed.
Your Honor, objection is to compound.
Yeah.
And I don't.
Sustained.
They did not change it.
Your Honor, I object and ask that whatever question there was.
Can you pose a question?
Sure. When you saw that factual acknowledgement in the manner that I've just read, in any of the iterations leading up to the 28th, you communicated with the state and asked them that it be changed. True?
Yes.
They did not change it. True?
No, they did not.
Mr. Sledge still initialed that, correct?
Correct. And that's an example of sometimes, as other counsel has asked, you try to get everything you want in a negotiation. Some things you may have to live with. And ultimately, this was an item where someone could try to argue whether two things are true at the same time. That is this just a boy-girl and another boy issue, or is it a YSL issue? But a decision was ultimately made that if it wasn't getting changed, we either had to live with it or stop the process. And ultimately, that stayed.
But the reason that you wanted it changed,
Hold on.
when you spoke to the state, you told them that that information was not accurate. True?
True.
You told them that this wasn't the factual acknowledgement that referenced it being done on behalf of YSL, that was not true. This was about a girl.
Your Honor, objection
about-
as to the compound nature of that question.
Sustained.
You told them that that incident was not about a gang-related incident. True?
True.
You told them that it was about a dispute over a girl. True?
True.
But they did not change it.
Objection asked and answered.
Sustained.
Were you present? You were present in court when Mr. Sledge testified that he thought that he would have an opportunity to, notwithstanding his initials, explain his answers if put on the stand. Did you hear that testimony?
I did.
Did you, again, without going into any privilege and to your observation, well, actually strike that. Did you have a conversation with the state about whether or not Mr. Sledge would be able to explain anything that he had some disputes with in the factual acknowledgments?
The conversation was had back when we were doing the plea, and then even since then, it's always been broadcast or at least made clear by me, hey, if there are some differences in some of the content of some of these, my client will ultimately want to explain. If you put him on the stand and he testifies, he's going to want to explain what he means, as is when he acknowledged this, because something can be true, but also be true with other components to it. It's not always just one way that one person sees it as opposed to how another person sees it. And he wanted to be able to at least explain that. I think he often referred to it as his truth. And that was really him just wanting to explain.
You discussed that with the state?
Yes.
Objection asked and answered.
Overruled. You can answer.
I would say yes. And again, sometimes the state would agree and they would make changes. Sometimes they would not agree. But it is incumbent on me to make sure, hey, eyes wide open, full disclosure, we've told you. So it was not going to be a surprise that, well, Mr. Sledge may have a difference of opinion.
It was your observation that the state wanted this plea to go through as much as Mr. Sledge did. Is that true?
Objection, Your Honor. Relevance as to, and speculation as to what the state wanted.
That wasn't what he asked. Overruled.
True.
I had a belief.
Okay. That's also not what was asked.
Okay. Well,
maybe ask your question again.
Yeah.
And relevance as to what the state wanted.
Based upon your conversations with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement, you formed or you observed that the state was just as interested in getting this plea done as Mr. Sledge was. Isn't that true?
So objection.
Go ahead.
Objection. It calls for speculation about the state, and whatever his observation is or belief was is not pertinent to any material.
Sustained.
Okay. Was it your observation that the state wasn't really concerned with Mr. Sledge? They really wanted Mr. Williams?
Same
Sustained.
And I have a motion as it relates to that.
Sustained. Ask your next question.
Okay. I thought you were waiting on the emotion. All right. Before Mr. Sledge was brought out into court on that video that we saw and entered the plea, I know there wasn't a proffer session, but separate and apart from that proffer agreement, the one we talked about earlier that was mailed to you, did you ever get an email from the state saying, hey, we want to talk to him before he enters a plea?
I'm not sure if they asked, but on the same token, my client never expressed an interest in talking to him. So I can't necessarily say it was the state or the defense that kept that conversation from happening. Ultimately, the conversations really were just the negotiations back and forth.
Okay. I got a question I want to jump ahead and ask you about first and then come back to the plea. So the plea is entered on December 28th, 2022, right?
Yes.
You had that meeting that was talked about on June the 9th of 2024.
Correct.
Right? At any point between December 28th of 22 and June the 9th of 2024, did the state ask you to bring your client in for an interview?
Objection, Your Honor. Relevance.
I don't believe so. I know we didn't meet with the state until we ultimately did in June of this year. But we always just sort of figured we were standing by, and it was always our hope we weren't going to have to testify. So we were hoping, hey, we're on the sidelines and we're no longer relevant in this. And then ultimately, it was this year that they said, we need to sit down with you, and yes, you will be testifying.
In 2024.
In 2024.
In the middle of the trial.
Objection,
Sustained.
Okay. How about this? Did the state ever send you any questions that they might want to ask your client?
Objections, Your Honor. Relevance as to whether or not the state ever sent any questions.
All right, so move on to your next question.
You knew when the plea was entered in December of 2028 that Mr. Sledge was a potential witness to be called to trial. Is that right?
Correct.
Okay. And after he entered the plea, he got out of jail. True?
Correct.
Objection asked and answered.
Sustained.
He didn't just get out of jail as a result of entering the plea, though. Am I right? There was a bond component of that also, wasn't there?
There was, but...
In fact,
Your Honor,
there
I
were
ask that the witness be allowed to finish his response.
Yes.
I'm sorry. I thought you were done. Go ahead, sir.
Well, I was going to say, I think the bond, we worked that out as part of the plea as well, so that was not going to be an impediment to him getting released. So, in other words, it really sort of was all connected.
His plea was on count one, the RICO plea, the RICO charge, right?
Uh-huh.
He also pled guilty on count 30, the possession of a firearm by a convicted felon charge, right?
Correct.
He was sentenced on count one.
Correct.
His sentence on count 30 was left open until after this trial concluded, correct?
Correct. In my practice, I find that it's not atypical for states when they do enter into an agreement with a defendant to try to have something held over so that the defendant's participation, they can make sure the defendant just doesn't show up and show out. They come and do what they indicate they're going to do. And therefore, count 30 being held open was not atypical.
Right. His plea agreement and his plea required that if called to testify, he come in and he testify truthfully,
Correct.
Consistent with the plea agreement, correct?
Correct.
Because count 30 was left open in terms of sentencing, he couldn't get out of jail unless he got a bond on that charge, true?
Correct.
The state consented to a bond on count 30, didn't they?
Your Honor, I'm going to object as to characterization, and the court can check, and I will not speak on evidence, but I believe that this is a matter that...
All right. How much longer is your cross going to be? Because we're approaching the lunch hour.
More than a half an hour.
Okay, let's break for lunch. And I think we've got a couple of motions to deal with. So let's say, it's 12:30 now. Let's be back at 2. All right, what I may do, because I have a lunch meeting, is let's break now and let's just come back early. So I don't know how long 2 motions and whatever else we have to deal with is going to take. Can we all be back at 1:15?
Yes, Your Honor.
All right. I'll see y'all then.
Thank you, Judge.
Thank you, Judge.